Robert Morales.
Ait squel siemp sea, siemp salhuan, siemp Hul'qumi'num. Want to take this opportunity to begin by thanking the National Chief for inviting us to come and make a presentation here this morning. Want to recognize our relatives and friends here in Ottawa, the Algonquin, for welcoming us here today. Recognize our national chief and regional chiefs and delegates, elders, and fellow First Nations. As was indicated, we're here this morning to make a presentation on some work that we're currently doing before the Inter-American Commission on Human Rights, which is based in Washington, D.C. My traditional name is Thalfit, Robert Morales. I'm Chief Negotiator for the Hulquminum Treaty Group. And I got to find the clicker. Oh, here it is. So our group has been to Washington, D.C. now 3 times to appear before the Inter-American Commission on Human Rights. We have launched a petition there. Our group has 6 First Nations: Cowichan, Halalt, Lake Cowichan, Penelakut, Laxon, Tsiminas. We are Coast Salish, and we live on Vancouver Island in British Columbia. It's a photograph of our latest trip to Washington, D.C., our leadership after our hearing concluded, along with our legal counsel, Rob Williams, who will be speaking in a moment. Our issue deals with a very particular set of circumstances that we find ourselves in. On the east coast of Vancouver Island, there was a grant of land in the late 1800s. And this grant was made by Canada to a private railway corporation. 2 million acres of land was given away in private fee simple ownership. That included 90% of our traditional territory. We found ourselves in a situation where we were unable to deal with that in the modern treaty process because of the policies of Canada and British Columbia. And so we've decided to take our case to the International Forum. There are 2 streams of rights for Aboriginal or Indigenous peoples. There's the domestic Canadian system that we all are familiar with, Aboriginal and treaty rights through constitutional and common law. But what we found is that there is an implementation gap, or at least we're calling it an implementation gap, and a long history of denial that our title and rights exist, and a refusal on the part of government to recognize those rights. Perhaps it's due to attitudes that exist, such as this. The Prime Minister at a 2009 G20 conference made the comment that Canada has no history of colonialism. So we've turned to an international approach, international or Indigenous human rights under international law. Under the international system, there's the United Nations, which is global. There's general human rights, and we know of the Declaration on the Rights of Indigenous Peoples. There's also a regional organization here in the Americas, North America, Central America, South America. And all of the countries belong to the Organization of American States. The Organization of American States has a charter that deals with human rights and the American Declaration on the Rights and Duties of Man. Under international law, There's two areas that we can look at. First is hard law, called hard law, which would be binding on states such as Canada. Treaties, covenants, conventions. Countries must take steps to comply with those. And then there's customary international law. Then there's what is referred to as soft law, which is not directly binding in and of itself, and it includes resolutions of the General Assembly and declarations. In the Americas, there is a human rights system. As I said, all countries belong to that, with the exception of Cuba. The Inter-American Court on Human Rights made this statement, that if a state signs and ratifies an international treaty, especially one concerning human rights, it has the obligation to make every effort to comply with the recommendations of the Inter-American Commission on Human Rights. In their recent report, the Inter-American Commission made this statement. The duty of Organization of American States, member states, is to promote and protect human rights, stems from the human rights obligations established in the OAS Charter and the American Declaration. There was a recent report, as I say, put out by the Inter-American Commission called Indigenous and Tribal Peoples' Rights over Their Ancestral Lands and Natural Resources. I would encourage you to get a copy and read through it. It's an excellent report and really sets out the approach that the Inter-American system is taking. I'll quickly go through just a little bit of a background to our case. Canada challenged us when we filed our petition on what is referred to as admissibility. Canada said that here within Canada there are effective mechanisms. They said we can go to court as Hul'quminum to establish our case, or we're currently in the treaty process. Either one of those two processes could be effective. As part of our strategy, we reached out to other First Nations and First Nation organizations. This is a list of those nations and First Nations organizations. We wish to thank them for their support. And we also got support from human rights non-government organizations such as Amnesty International and Lawyers' Rights Watch Canada. Those interventions really helped to move our case forward. At the admissibility ruling, the Inter-American Commission found in our favor and said that they would deal with our case. They said that by failing to resolve the Hulquminum claims with regard to their ancestral lands, the British Columbia treaty process has demonstrated that it is not an effective mechanism to protect the right to property alleged by the HTG, and that there is no due process of law to protect the property rights of the HTG to its ancestral lands. It's a very significant finding by an international human rights body. They went on to say that the Canadian court cases that Canada was bringing forward dealing with Aboriginal title do not seem to provide any reasonable expectation of success, because Canadian jurisprudence has not obligated the state, that is Canada, to set boundaries to demarcate and record title deeds to lands of Indigenous peoples. And therefore, in the case of the HTG, those remedies would not be effective under recognized general principles of international law. Another very important statement, that the Canadian court system has not been effective in terms of the recognition and demarcation and titling of Indigenous peoples' traditional territories. We're now have just concluded the hearing on the merits. The Inter-American Commission is considering our case with respect to the right to equality, the right to profess and manifest and practice a religious faith, which has to do with our culture, the right to culture, and the right to property. They're looking at all of this under the American Declaration on the Rights and Duties of Man. And so, as I say, we have concluded the merits process. This is the first case from Canada dealing with Indigenous people's land rights to make it this far, and we are now waiting for a decision. In terms of next steps, implementation is going to be important. If we receive a positive decision from the Commission, this will become vital. Canada could make a decision to ignore the decision. The Inter-American Commission does not have an enforcement mechanism. So we've been reaching out to other organizations. Amnesty International is currently supporting our case. Other human rights organizations are supporting our case. First Nations are supporting. And we need to continue to build the knowledge of and credibility of the Inter-American Commission here in Canada, which would make it difficult for Canada to simply ignore this important decision. There's not a lot of knowledge of this system. When I went to law school, we didn't study this. We didn't learn about the Inter-American Commission system of human rights. So it's important that we educate ourselves. So with that, I'll turn it over to our legal counsel, Robert Williams.